Good afternoon and hello. My name is Kate Schenk and I'm the Deputy Director of Legal Aid Chicago. Welcome to our sixth session of our series, The Emerging Legal Crisis Facing Chicago's Black and Brown Communities. Today's session will focus on the school to prison pipeline. It is my pleasure to introduce our panelists for today. Veronica Rodriguez, who is a youth organizer from the Brighton Park Neighborhood Council. Two Chicago Public School students who work with Veronica, Rocio Almazan and Destiny Miranda, both from Legal Aid, and from Legal Aid Chicago, Ashley Fredhold, who's a supervisory attorney in our Children and Families Practice Group, and Richard Cazzola, who's our training supervisory attorney. We'll also hear from Melissa Pachola, the director of our Volunteer Services Practice Group. We're gonna get started this afternoon with Veronica Rodriguez. Veronica?
Hi everyone, thank you for joining us today. My name is Veronica and I'm a youth organizer with Brighton Park Neighborhood Council. BPNC is a multi-generational community-based organization founded in 1997 and is led by students, parents, and community members on the southwest side of Chicago. Our goals are to create safer communities and schools, ensure that our community has housing to center youth voice, protect immigrant rights, and end all forms of violence. Today, I'm here with two students from Cary High School who have been involved with BPNC and their community since middle school. They are amazing and have wonderful ideas on what schools can and should be like through their work. We will be covering what the school to prison to deportation pipeline is and how it looks like in our communities and what our response has been to try to stop it. So in our communities, we have seen the school to prison to deportation pipeline harm and traumatize students and parents. This anti-Black and xenophobic instrument is enforced through police presence in schools, harsh disciplinary policies, and school personnel. It's kind of like a domino effect, right? So once a police officer is forced to come into contact with a student because of an incident, it can lead to incarceration, to being tased and pushed down a flight of stairs, body slammed to the ground. And these are all things that we know because we have seen videos. We have read stories of students who have shared these experiences, right, of what it's like to have police officers in school respond to school incidents, right, or student conflicts. And if it doesn't lead to that, it often leads to students facing expulsions, right, detentions, missing class, and sometimes dropping out, or usually dropping out. And we don't talk enough about how these decisions and how these events impact a student and how it plays a vital role in the students' mental health, their well-being, and even in their perception of belonging and safety. We have to talk about these student needs, right? Because when we talk about students' needs, we also have to address the issues that they're facing at home and their communities, right, and their personal lives, because these are all things that affect them, right? And we're supposed to be thinking of schools, and schools are meant to protect, to nurture, challenge, and teach students, but we don't see that. On one of the bullet points that we added on the slide, we talked about increase in surveillance, right? And we want to talk about a tool that the Chicago Police Department, ICE, Immigration Customs Enforcement, and many more agencies use. It's called the GAIN database. So through FOIAs, which is the Freedom of Information Act, that the community and community organizations have filed, and through the Office of Inspector General report that they launched about 2 years ago, investigating the SRO program. So SRO stands for the School Resource Officer, which is what CPS, Chicago Public Schools, refers to as their police officer stationed in schools. So through these research and investigations, we learned about how the GAIN database plays a role in the SRO program. We quickly learned that CPS had accessed this GAIN database 90,000 times. That means that CPS had access to add and view names of students in this racist, inaccurate, and useless database. So looking on the data at this graph, the numbers are kind of disturbing, are really disturbing, not kind of, but really disturbing. We're seeing how young people make up about 33,000 of those names. And so the GAIN database, right? Like, what is the GAIN database? If we go to the next slide, we'll be able to see the risk and impacts that being on the GAIN database does to Latinx and Brown and Black communities. So the gang database is a name used for the maintenance of information about an individual's designation as having a suspected relationship to gangs by the Chicago Police Department. And so police fill out a contact card after any interaction with an individual and can mark them as gang affiliated based on a wide range of criteria. So some of that criteria could be clothes, tattoos, other markings specific to a street gang or not, individuals' associations to other people suspected in a gang, the amount of recent gang violence in a person's neighborhood. And people who are listed on the gang database are not notified, and there is no process to remove a name without going to court. So to know that this is a tool that is being accessed through CPS on school grounds is really disturbing and kind of alarming, especially knowing that this gang database is being accessed by ICE, thinking of the names on that list and how vulnerable they could be, right, by knowing that ICE has access to their names, to their information.
So I'm gonna be talking to you guys about my transition into high school, from middle school to high school. And to start off with, is one of the things that I wanted to include is that the heavily staffed amount of security and many aspects of the building that made it seem enclosed and trapped in. I know that when I first walked into high school, it was like just the feeling of like having like a lot of security guards that I normally did not see so much in my middle school. I was used to seeing maybe one or two, but just that transition into high school, it was just hit with like, I guess in a way, I was criminalized already just by going to school. And so my second point is more disciplining of kids through consequences that increasingly became more negative and harmful to the student. And what I mean by that is, I guess what schools tend to do is, in a way, threaten the student who has like done something wrong, and the threats get increasingly worse and more harmful to the student, because more days of suspension, getting expelled from the school, and overall that's just like not a way to handle those types of situations. And another point is that middle school had more carefully executed interactions with students who were fighting or had an issue or problem. I know that the security at my school, they were able to handle situations well and clearly. However, in high school, it's more like if the security guard doesn't know how to handle it, they'll just figure it out on their own. So that's just something else that I noticed. And one of my last points is that security was mainly to make sure students got in and out of school safely. So in my middle school, they made sure that we made it out and we made it in, making sure all the students felt safe. However, transitioning into high school, I had the mindset that they're only there because of violence that has occurred in my school. And that whole making sure that we went out of the building safely and into the building safely, it kind of just like went away. Like that just lost meaning to me when I went into high school. So next slide. Sorry. This is a quote from a young person at Aseda's daughters. Their quote highlights how police cannot under any circumstance play a role of safety in the life of a student of color. Cops enforce laws. Schools are meant to nurture and help us learn. Next slide. Oh, let me read the quote, my bad. Thanks. I've always felt unsafe and uncomfortable around police, especially within my schools. People are starting to realize it doesn't stop at schools. It doesn't stop when you walk in those doors. It continues. Next slide. So this is a short timeline to show how CPS denied having access to the gang database. But then a year later, after students and parents pressured them to terminate the $33 million contract. They continue to try to keep the police program by making reforms to it. But that is not the solution. This summer, students organized cops out of CPS and pressured the Board of Education to relocate those $33 million into more resources like art programs, restorative justice counselors, student spaces, housing assistance, free technologies, and so much more. We want to end the school to prison pipeline, and that means no police in our schools at all. Now I'm going to pass it over to Destiny.
Hi everyone, my name's Destiny, and we could start off by just looking at the picture or the slideshow. It says on average day, police bring 21,600 bullets, 360 firearms, 180 tasers and 360 taser cartridges, 180 cans of pepper spray, 180 expandable batons, and 180 pairs of handcuffs into CPS schools and hallways. About 15% of CPS students have IEPs, but 30% of police notifications target students with IEPs. So let's talk about why police are in this conversation around school discipline. When a student does something, who gets called to respond? Police. Sometimes security, never a counselor, never a restorative mediator, or even a nurse. School-based policing unjustly impacts students with diverse learning needs. Students with IEPs make up only 15% of CPS populations, but over 30% of police incidents involve students with IEPs. An IEP is an individualized education program, which is a plan that describes the special education, instruction, supports, and services that students with disabilities are legally entitled to receive. More than 95% of police incidents in CPS involve students of color. To have police present in our schools is anti-Black, period. 2/3 of police incidents in CPS involve a Black student. Our data demonstrates that more than 66% of police incidents in Chicago public schools target a Black student, while Black students make up just 35.9% of CPS's population. If you guys could go to the next slide, please. We know that conflict and violence are present in our communities and schools. We also know that violence is a symptom. CPS students are struggling. Our schools aren't being funded. We don't have nurses, resources, or support from CPS. There are 16,451 CPS students without housing. Students across the country and Chicago are demanding for more. Please make sure to stay connected with the work students are doing by supporting us through social media, reading our report at copsoutofcps.com, and showing up at our events. Thank you. And now I'd like to pass it back to Vero.
We just talked about a lot very briefly, and we can talk about this forever, right? To talk about the impacts that policing and these harsh decisions have played a role in students, right, in our communities. But luckily, if you have any questions, make sure to drop them in the chat. And now I'm going to pass it on to Ashley, who will continue this conversation. Thank you.
Hi, everyone. Welcome. I just want to say thank you so much to Veronica, but also especially to Destiny and Rocio. It's so important and so nice to hear from the students. We're about to talk a lot about what this looks like from the perspective of a lawyer and throughout the state of Illinois and nationally. And I really appreciate them coming and telling us what it's like to live through it for them. So today we're going to talk about what the work Legal Aid Chicago does around the school to prison pipeline. So I work on the education law team, which is a part of the Children and Families Practice Group here at Legal Aid Chicago. We work on special education, school discipline, Title IX, bullying, all different sorts of education matters. Today we're going to focus on our school discipline work. So today what we're going to talk about is, what does school discipline look like in the current environment, because it looks different from when a lot of us attended school. And why does exclusionary disciplines, suspensions, expulsions, push-outs, Why does that matter? And the short answer is because the negative effects go way beyond academic. Then we're going to talk a little bit about what rights do students have, because really, where do lawyers come into this? The good news, which we'll get to, is that there are rights for students, but our challenge and our battle is in enforcing them. And then we're going to talk a little bit more about what Legal Aid Chicago is doing in the future to combat the school to prison pipeline. So this first graphic is from the Advancement Project, and we're going to go into this a little bit, but the overall point of this is to really talk about how public schools look very different than they did decades ago. There's an increasing presence of police, searches, surveillance, and you put that in the context of underfunding, high stakes testing, and school closures, which are especially relevant here in Chicago, where in 2013 we had the largest one-time closing of schools when we closed 49 schools all at once, the largest to ever happen in the United States. So this is the environment that schools exist within right now. So on the next slide, we're going to look at some of the statistics that surround this phenomena of the school to prison pipeline. And what the number on this slide that I really want you to focus on is that one at the top, the 3 million. That's 3 million students receiving an out-of-school suspension, which could be one day, but could be way more than that annually in our schools in the United States. So I just want everyone to reflect on a minute, how many days of school does that reflect? More than 3 million days of school. How many hours of instruction does that reflect? That's an enormous loss of educational opportunity that happens every year. The next slide we're going to look at a little more focusing on what does it look like from a race equity standpoint. And what is very clear from all the statistics in Illinois and nationally is that Black students and students with disabilities are disproportionately impacted by zero tolerance and other exclusionary school discipline. And even as schools are moving away from zero tolerance, these disparities persist. And you can see them in the numbers there, in which Destiny and Rocio also talked about, that the numbers are always misrepresented when you start looking at Black students and students with disabilities. And on the next slide, what you'll see is when you have the unfortunate circumstance that because of that, Black students with disabilities are even more negatively impacted, that they are 3 times more likely to be suspended than similar white students. And that also means that they're 4 times more likely to enter the juvenile and criminal justice systems. And so when we talk about the school to prison pipeline, this is what we're talking about, right? Why does exclusionary discipline matter? Because it goes way beyond the harm of a missed class. What research has shown is that when you are suspended, that student is more likely to be held back a grade and not be promoted. They're less likely to graduate on time. They're more likely to be referred to law enforcement, and they're more likely to enter into the juvenile justice or criminal justice system. So you see this series of events that starts really with someone being pushed into this pipeline by exclusionary discipline. You can see more of these stats on the next slide. And what I really want to focus on here is the kind of advanced reading that was sent out yesterday by Justin. There were some articles. I think the first article was a database that you can look that's from ProPublica that allows you to search these kinds of statistics that the U.S. Department of Education collects. And you can see what it is for whatever school district you want to look at. So it's really a great tool, especially for Illinois, to see what does my school district match up, because it's not just CPS. I'll be very clear about that. I think also on this side, I'd like to point out that students suspended or expelled for a discretionary violation are nearly 3 times as likely to be in contact with the juvenile justice system within a year of that happening. So this is not some extended effect. It's happening right away. So the question that might come to some people's minds is, but what about school safety, right? We want students to feel safe in schools. I think the first thing I would say in response is, listening to our students today, I think it's clear that from their perspective, police in schools does not necessarily make them feel safe. And in fact, it has, for many students that we have represented and that we have spoken to, makes them feel the opposite of safe. And the statistics we just went through reinforce that that's a logical conclusion for them to reach. I think it's also important, though, to look at what does the research say. The research agrees with students that there is no empirical proof, or there's been no empirical proof so far, that exclusionary discipline, suspending and expelling students, is proven to make schools safer. In fact, the Government Accountability Office just released a report this summer showing that there's no proven connection between the efforts that occurred in the previous administration to reform school discipline practices and the proliferation of school shootings. That those two things are not connected. So when we look at school reforms, it is not supported to say, well, this is going to lead to more violence in schools if we stop pushing out students. However, there is research that shows and establishes that zero tolerance policies do result in those negative effects that we showed just a few slides ago. We also want to point out that other research also establishes that a social emotional approach to character development does actually reduce behaviors in school, and that strong partnerships between communities and schools is vital when we're talking about creating safe and welcoming schools for our students. So we want to take a moment to just talk about what does this look like in the time of COVID-19, right? School has clearly radically changed during COVID-19. And almost everyone right now is either in a hybrid or some sort of 100% remote learning scenario. So some of the things that we're seeing, we just want to reflect back, the challenges of students who are in remote learning. We're seeing reports that schools are using truancy laws to essentially report students who are not logging on as much as they would like them to. This is, of course, a really concerning practice because a lot of those log-ons or lack of attendance might be a reflection more of our digital divide, where students are having a hard time because they don't have access to devices or Wi-Fi. And now they're being called truant for it. We also see the concern that a lot of schools are now video recording their entire class, which is a whole nother kind of level of surveillance that didn't exist before and is really uncomfortable for a lot of students. We're also seeing schools talk about teachers being able to ban students from a classroom if they're doing something that they don't like. This, in our view, is a suspension and should be called as such and needs to be recorded as such. So this is another thing we're keeping an eye on. And of course, there are students who are returning to the classroom or will be soon. And for those students, we really want to think about how is that return being dealt with, and is it being looked at in a trauma-informed way? Everyone, staff and students, is experiencing new trauma, and they're experiencing increased stress. And there's new things being asked of them. And we want to make sure that students are not being disciplined for things that honestly might be a manifestation of what they're going through in these really difficult times. So let's talk about what rights do students have? We know that this is a problem, but where, as a lawyer, can we come in? We're not going to get in today. There's a lot of overlapping areas here like free speech in schools, school search rights, but we're really going to focus on what rights do students have around exclusionary discipline. So if we go to the next slide, we can see that in Illinois, there is a state law that the Illinois General Assembly in 2015 basically decided that exclusionary discipline is negative and it's having a negative impact on our students, and they wanted to reduce it. So they put in place new requirements that before a school can push out a student for more than 3 days in a row, they have to exhaust behavioral interventions and show that the student is a safety threat or a substantial disruption. So behavioral interventions would be things other than a suspension that they should attempt first, and now they are required to attempt first. That could be a restorative justice meeting between students who aren't getting along, who are having conflict. It could be a student who maybe was found with drugs, referring them to drug counseling instead of kicking them out of school. These are all things that could be implemented instead of just kicking a student out of school, which really doesn't help anyone. Also, the law that was passed in 2015 went into effect in 2016, Senate Bill 100. That bill required schools to abandon zero tolerance policies in Illinois. And we also just want to mention quickly Goss v. Lopez. It's a US Supreme Court case from 1975. It kind of forms a basis of a lot of the work we do in school discipline because it essentially established that students they are entitled to due process in school exclusions. So you can't just expel a student, they're entitled to some level of process, which is usually a hearing before that can happen. And when we talk about that due process, as many things, the more the exclusion, the more due process you're entitled to. So when we talk about the suspensions and expulsions, an expulsion, right, would be a longer term exclusion. It could be anything from 11 days in a row up to 2 years. So students who are referred for an expulsion are entitled to a hearing with basic due process protections. And all of those protections that we talked about in the previous slide about exhausting behavioral interventions, those apply as well. This hearing is really where we would hope a lawyer such as Legal Aid Chicago would come in and help represent the student, because it really is has serious consequences. And we'll see on the next slide, why does this matter? And this is where it really gets down to, this is something that we talk about school expulsion and do know your rights presentations. This is the information that surprises people the most. In Illinois, a student can be expelled for up to 2 years. And that means they have no right to go to school. And it does not mean that even if the family had the means to move to a different school district, it doesn't mean that that would solve their problem. Because if you're expelled from one school district in Illinois, every school district in Illinois can enforce that expulsion. So it's a drastic consequence. Also in Illinois, if a student is expelled, they do not have a right to go to an alternative school. The school district may choose to enroll them in alternative school, but they could let them sit at home for 2 years. And that's a pretty shocking consequence that a lot of people aren't aware of, and unfortunately a lot of students and parents aren't aware of until after they have their expulsion hearing and realize, I didn't realize that this is how this was going to go. So we are really trying to work towards doing more know your rights, so people know to contact legal representation before that. Another phenomenon we see is transfers to alternative schools. So in lieu of an actual expulsion, a school will basically just transfer you to an alternative school. Many of the same protections would apply in terms of needing a hearing and needing some process, but we see a lot of violations in this area, and we see the proliferation of alternative school transfers. There's also a lack of clarity around it, as there's no time limit to it, and a lot of times parents are somewhat coached into it and told, well, we're going to expel your student, or you can agree to this transfer. So they kind of feel like they have to agree to it. And to reinforce that this is something that's happening more and more and more in Illinois, just your numbers for Cook County, in the school years 2018, 2019, and 2019-2020, 319 students in Cook County were expelled, but almost 1,100 students were subject to a transfer to an alternative school, which is a pretty scary number. So we also see informal push-outs. This would essentially be, we say informal, it's illegal. It's an illegal push-out where a student is repeatedly suspended but not given notice of the suspension, just told to go home early. That's a suspension. Or worse, where they're basically told just leave the school entirely, where it's essentially given a transfer form and said, get lost, don't come back. That, of course, would be an expulsion without a proper hearing. So we see a lot of those cases as well, where we need to advocate that at the very minimum, we need to have a hearing first before you can do any of this. So how does Legal Aid Chicago currently work to combat the school to prison pipeline? Primarily, we represent individual students in their school push out, school discipline matters to get them back in school. We also collaborate with other advocates on systemic issues, working with them to identify what kinds of trends, what kinds of other things do we see. And I say this because there are limitations to what we do. One, because of the problem I referenced a few minutes ago in terms of parents and students not always knowing their rights, not always knowing and thinking I should call a lawyer. A lot of parents don't jump to think I should call a lawyer to deal with my child's school. They just don't think of it as being an adversarial relationship, and they're uncomfortable sometimes with that. And it isn't that we don't get those cases sometimes until after a hearing has happened or after a student has been pushed out for a long period of time. The other limitation, of course, is that we have a lack of resources to take cases. We're going to talk about in a minute that thankfully some of that has been resolved. And now I'm just going to give you two quick examples of two cases that we represented. So Dustin was a high school freshman in a South suburban school. Throughout his freshman year, he kept having these conflicts with the same group of other students. It was, about 3 or 4 students versus Dustin. And they would mostly be verbal, but they escalated into physical fights 2 times. And after those 2 times, Dustin was suspended, but no other follow-up was done. There was no attempt at really having all the students come to a table together and mediate or talk about what was going on or try and sort out what the problem was. his mom came to school and said, you know, she felt that this group of students was bullying Dustin and she wanted a safety plan so that he could avoid them so they wouldn't have the same classes or the same lunch together. And that was essentially met with a meeting, but essentially ignored. And then they got into another fight. After that fight, the school referred Dustin, but apparently not the other students, for an expulsion hearing. So this was an example where they had an expulsion hearing, but mom asked for time to go find an attorney. She couldn't find one quickly enough. The school went ahead without her having time to find one, so she was representing Dustin on her own. Dustin wasn't even at the hearing because he had a final exam scheduled for the same time, and he chose to go to his exam instead of go to the hearing, so he never really got to speak for himself at all. The school presented their case for 55 minutes. Mom got to speak second. She spoke for 5 minutes, and then the hearing officer told her he had another meeting to go to. So, no surprise, Dustin was expelled for 1.5 years and transferred to an alternative school. We got involved, we went back, we pointed out not only the due process problems with their hearing, but the fact that they had never attempted, much less exhausted behavioral interventions. And I'm happy to say that Dustin is back in his school and that more importantly, we are now engaging in a restorative justice process between him and the other students so that that conflict can be resolved and not perpetuated every single day in the school setting. Brittany was another client of ours. She was a high school sophomore. She got into a verbal fight with another girl in her class and it ended up into a pushing. At this point, Brittany's family was somewhat on the radar of the school because they had challenged mom, questioning that she didn't live in the district. And it had gotten to the point where mom, they had pushed out the kids so much, this is the beginning of the school year, that mom had to go to the Illinois State Board of Education and enforce her rights that way. And she got her kids in school because she did live in the school district. So then Brittany gets in this fight and the school suspends her for 10 days. At the end of the 10-day suspension, Brittany goes back and the school calls mom and says, she can't come back here. She needs to transfer. You should go to a different school district. You should find a private school. Clearly, this is not appropriate. This is what we were talking about, an informal, illegal expulsion without a hearing, without a notice, and also advising parent essentially to commit residency fraud by trying to enroll in a school district where she doesn't live, ironically. So we got involved, went back to the school and said, one, this seems like retaliation for mom enforcing her rights, but two, you can't just push out a student. At the point we got involved, Brittany had already missed a month of school. So these cases are not without harm, even though we managed to get them back on track at the end. So we're going to talk a little bit later about that lack of resources that I referred to. Thankfully, we have a new grant that we're launching this winter. It'll be a great pro bono opportunity, and Melissa Pichola is going to talk about that in a few minutes. And now I'm going to turn it over to Rich Cazzola, who's going to talk about our work on another end of the school to prison pipeline, which is our work in expunging juvenile records.
At a building on the west side of Chicago, the following conversation happened. A woman came in and said, I got an envelope in the mail, or maybe it was an email. She was a Black woman who had been a nurse's aide for about 15 years. Her name was Jessica. The name is a pseudonym, but the story is real. She said, I've been a nurse's aide for 15 years. I passed the background checks for that. I always wanted to go to an LPN program and to become a nurse. I got into a program and I graduated a couple weeks ago and I went to apply for my license. This envelope that I have here, this piece of paper, was what I opened. And it told me that something that happened 20 years ago that I barely even remember is keeping me from getting a license. I was out one night with a friend and the police said we were out after curfew and they brought us to a police station. And now that's keeping me from getting the license that I have been trying to get. And I've also been admitted into an RN program on scholarship, and it's keeping me from getting into that program. Jessica thought about what had happened to her in the past. She thought she didn't have a juvenile record, but she did. That was just one of the myths, because she thought, because I never went to court, because I was never found guilty, because none of these things ever happened to me, I don't have a juvenile record. And other people come into the juvenile help desk that we run that says, I thought our records were automatically expunged when they were 18. They're not. Others have said, I have to wait till 18 to expunge my records, so they think the opposite. I have to sit around and wait till I'm 18 to expunge my records. And then still others, including many lawyers, say, well, juvenile court records are confidential and they're sealed, so nobody can see them anyway. But the reality is that they get out and they can prevent people from jobs, from licensure, and create all kinds of other barriers to people's careers. Next slide, please. What is a juvenile record? So juvenile records have two primary elements. Number one are law enforcement records, police department records. Arrests, some are arrests that go to court, some are arrests that don't go to court, some are things like curfew or riding a bicycle on a sidewalk. Those can appear as records. In Illinois, juvenile records include all records under 17 for all years. And then since 2014, January 1st of that year, all records for people under 18. Illinois changed the age of when you're a juvenile, raising it 1 year then, in part based on brain science that talks about how immature 17-year-olds can be when it comes to getting arrested. And so the age was raised. Next slide, please. Next slide. So what is eligible for juvenile expungement in Illinois? How can those records be cleared, and why does it make a difference? The simple answer is just about any arrest or offense can be expunged in Illinois, and then the exception is there in small print. First-degree murder, if you're found guilty, and sex offenses, and any case that was transferred to adult court. So if it goes to adult court, those are under the adult expungement laws, not the juvenile expungement laws. Now, you may wonder about who we see on juvenile expungements, and one is a group like Jessica, people who had something that happened to them years ago, maybe a couple of things that they got involved in, and have had basically lives that have been clear and clean since, and these pop up. The second group is people like Brittany and Dustin, who Ashley talked about. Kids who get in trouble in school. They get in a fight, and that leads to a police encounter, and it leads to a police record that needs to be expunged. Or they get involved in other kinds of things. What we do is we work with clients to find out what their eligibility is, and then we work to expunge them. Next slide. One of the first things that you need to know, and this goes back to the days of Jane Addams, but was recently reinforced by a new law at the beginning of 2018, is that juvenile adjudications of guilt are not convictions. The whole idea of the juvenile court that the women of Hull House envisioned in the late 1800s and the early 1900s, including Ida B. Wells, is that juvenile adjudications are not adult convictions because juveniles are different. And so what the law now says is that a juvenile adjudication shall not impose upon an individual any civil disability ordinarily imposed or resulting from a conviction. So these are the cases that get to court and you're found guilty. So Jessica wasn't even in that situation. But if she had gone to court and she had been found guilty, her license could not have been denied. And then the section below, that unless allowed by law, and it wasn't in this case, adjudication shall not prejudice or disqualify the individual from civil service, from holding public office, or receiving any license granted by public authority. So you may still be wondering, how is it that this prevented Jessica? We'll get to that. Under the Juvenile Court Act that has gone back to the late 1800s, in general, all records were called confidential. Even now, with a new passage of the law, it clarified that and said that means they're sealed. Only certain people can see them. Expunged records, number one, are destroyed. In other words, the records are no longer there. And the offenses are treated as if they never occurred under the law. Next slide, please. So what does that mean? Who can see your record? An expunged record is very, very limited. The US immigration authorities can see it, the military, and certain times the FBI, if they have the record. Sealed records can still be seen by multiple law enforcement agencies, review boards, the Secretary of State's, school officials, presidents of park district, and more. And we'll come to that in a second about Jessica's case. Next slide. If it's only sealed, and I'm going to start with the bottom one here, some jobs still are able to see that. There are certain fast food restaurants that for some reason, these are still popping up on. There are some jobs and licensing applications it does when you have a fingerprint check. Now, why is that? And this gets to Jessica's issue. Before 2010, Illinois used to send all of its juvenile records to the FBI. The FBI collects those records, it collects whatever the state has. When you go for a license, like a nursing license or something, whereas the license has a higher level of security, so financial people, people working in banks, licensing like nursing, school teachers, the Illinois State Police sends that fingerprint to the FBI, and the FBI returns what they have on their records there. In Jessica's case, it was this incident from 20 to 25 years before, when she was shortly after she graduated as an honor student at a high school and was out late with friends. So what the licensing agency said was, well, we don't know that this didn't turn into a major crime. And we said, yes, you do, because you have a background check that shows all the major crimes. And they said, well, sometimes things slip through. So what we did was we had her record expunged. We also had her send a letter from the court saying there is no court case here. And eventually that cleared up her situation late on a Friday afternoon. And the following Monday, she was able to start her LPN program. What's important, though, and why it's important for her record to have been expunged, because that's the thing that finally cleared everything up, is that the law explicitly says about expunged records what it doesn't say about sealed records. It says an expunged record may not be considered by private or public entities in employment, licensing, or certification. And the Licensing Act says you can't even ask about those offenses if it's an expunged record. So that made her case stronger. It helped her get her license. And she now has a job in a hospital working as an LPN. Next slide. Is this complicated? Some of you may have done or worked on adult expungements. Juvenile expungements is fairly straightforward. You get the rap sheet from the Chicago Police Department or from the Juvenile Probation Authorities. Our office, as well as other legal aid offices in Chicago, are able to get them through the Juvenile Probation Office. You then match the arrest to the court dates. You see how many cases didn't go to court, how many did. You explain in the pleadings, which are form pleadings, which are the ones that never made it to court, which were the ones that were in court and were dismissed or not guilty, and then which ones were the guilty. And then you prepare the paperwork. You get the client to sign, and from the date you sign, the court will set a court date of 45 days. It will notify both the police department and the Illinois State Police to see if they have objections, as well as the state's attorney. And in the vast majority of cases, there are no objections. Some cases, the Illinois statute on juvenile expungement says the judge shall expunge. So if it's only an arrest that never made it to court, the judge shall expunge. If it's a case that was dismissed, nolliprost, SOL, all those terms that criminal lawyers know, the case did not make it even to a trial, those cases, the judge shall order the expungement. If it's a case where there was a finding of guilty, then there's a 2-year waiting period until after the case was closed, and the judge has discretion to decide whether or not to grant those expungements. The vast majority are that first group where the statute says shall. We have seen people who have as many as 20 to 30 to 40 arrests in the inner city from Black and brown neighborhoods who have 1 or 2 court cases, or in some cases, none. The court grants over 98% of the expungements we are involved in. We normally have a desk at the juvenile court. Since COVID, that has not been going on, and we've been working remotely. This summer, we had about 350 expungements once the court reopened. Expungements meaning total numbers of arrests. So the number of people on this was less once the court came back. Of those 350 plus expungements, all were granted. The vast majority, again, were ones where it said the court shall grant the expungement. Next, please. Our work at the Juvenile Expungement Desk, remote and in the court building, where we heard those stories and where we see those students like Dustin and Brittany, is as follows. When we first got involved in the late first decade of the 2000s, it was under 500. As we have gotten more resources and as we have established collaborations with the court, with the state's attorney's office, collaborating work relationship with probation, we have seen the numbers greatly increase. And in 2017 and 2018, as the laws changed, the numbers skyrocketed in terms of how many we were able to expunge. A report from Northwestern and the legislature says that around 20 to 25,000 arrests occur in Cook County every year of juveniles. So we're only catching, even now, maybe 20% of the total of an arrest in any year. But it's a great increase since the numbers of many years ago. We're also trying to deal with the gap, with that issue of how to deal with that FBI gap on those 2010 and before cases by trying to collaborate with state licensing agencies to try to come up with a solution for that. And we're trying to bust those myths that we talked about at the beginning, so that people like Jessica can have jobs, so that people who otherwise would not have an opportunity to work have that opportunity for licensing and work. And now I'm going to turn it over to Melissa Pachola, who is the head of our volunteer services unit, which really focuses a great deal on all kinds of expungements.
Wonderful. Well, thank you, Rich, and thank you, Ashley. And your advocacy for youth during this unprecedented time is essential. And I'm grateful to both of you for your unbelievable work. And for those of you who may want to help us in this, I'm going to highlight some of the ways that you can get involved in Legal Aid Chicago's work. At Legal Aid Chicago, we have over 20 different volunteer opportunities. Our volunteers work alongside us to help meet the needs of our clients and are essential to helping us achieve our mission of bringing about justice for all. And you can see here the impact that our volunteers made in 2019 alone. As Ashley mentioned, we are thrilled to be able to announce a new pro bono project, Disrupting the School to Prison Pipeline. We are in the early stages. Our grant doesn't officially start until October 1st. And we are working right now on staffing and developing that training. But we are excited to bring you the opportunity to help us address 2 key issues: school discipline and juvenile expungement. This project will consist of 2 opportunities, one focused on representing students in school discipline cases, particularly expulsion. On the expulsion side, you will help students by representing them at expulsion hearings, as Ashley described. Not only is this advocacy critically important to keep a child in school, it's also a great opportunity to build hearing and advocacy skills. These are short-term cases that wrap up within a few weeks, so there isn't a long-term commitment, but the impact on the child is substantial. The other opportunity will focus on juvenile record expungement. Assisting with criminal record expungement is a transactional, paperwork-based opportunity. This is a limited scope opportunity as well, but a very meaningful one. And you can help by preparing petitions for youth who are eligible and clear those records so they don't end up facing consequences later in life. There may be some clients who actually have both types of issues, but more commonly, they will be clients with one issue or the other. And our dual approach is designed to help as many youth as possible and really make an impact on the school to prison pipeline. You can find more information about all of our volunteer opportunities on our website, and you are welcome to reach out to me with any questions that you may have about any of our opportunities and how you might be able to help. And for those of you looking to volunteer on our new Disrupting the School to Prison Pipeline project, more information will be circulated in a few months once we have developed the training. And I invite you to contact me now with questions about that project. And now I'll turn it back over to Kate Shank.
Thanks, Melissa. And thank you to Ashley and Rich, to Veronica, to Rocio and Destiny for those really terrific presentations. We're just so grateful for our partnership with the Brighton Park Neighborhood Council, and particularly thankful that the three of you could join us today. This concludes the planned content portion of today's presentation. In a moment, we'll start the Q&A portion. But before we do, I'd like to say a quick word about our Relay for Justice that just wrapped up on Monday. So together, through this relay, we traveled over 9,000 miles. We found respite at a paint party and a trivia night. We completed an in-person March for Justice as an organization, and together we made it to the steps of the Supreme Court. Thank you to everyone who participated and for making this new initiative a smashing success. It was a lot of fun, and we hope it will become a yearly tradition. The panelists are going to remain on to answer your questions, which you should type into the Q&A at the bottom of your screen. I know we already have so many great questions that have come in, so Ashley, if you could please take us through the Q&A.
Thanks, Kate. The first question I want to send over to Veronica. Veronica, we got a question saying, can you let us know how we can support Brighton Park Neighborhood Council? So Veronica, what's a good way if someone wants to get involved with BPNC?
Yeah, so if you go to our website at bpncchicago.org, you'll be able to see an opportunity to sign up for our newsletter. As well, on our presentation at the end, we had links or our users to the Student Strike Back, which is the student-led social media where we update our folks, our supporters on what's going on, our work. And we also do a lot of lives, events and stuff like that. You can donate to us if needed, if you're interested in that. And yeah, I would just strongly suggest also reading our report at copsoutcps.com. Thank you.
Yeah, thanks, Veronica. I have a couple questions here about school discipline, which I'll try to answer, some of them overlapping. One asked about what is a discretionary violation. There was a reference in one of the slides to discretionary violations. So I would say that a discretionary violation would be when you have an offense, as it might be called, in a student code of conduct that is something that's very subjective in terms of one person may see a student being defiant, another person may just see that student as being escalated or being emotional. So a discretionary violation to me would be something that it's a student being expelled or suspended for defiance, disrespect, and things of that nature that are really subjective, and where we see, and the statistics have shown nationally, where implicit bias tends to really play into what students are disciplined for those types of things. Another question, what is zero tolerance? So zero tolerance is when you have a policy that says, now outlawed in Illinois, but still present in some places, where the school district in their policies, their student code of conduct, has a policy that says, if you are in any sort of physical fight, you will be expelled. Right, that has no ifs, ands, or buts or considerations. And those types of policies where you don't take into account mitigating factors or other information about what was going on with the student or what their history is at the school have been said in Illinois, you can't have those anymore. And it led to a lot of exclusions. We got a couple questions about statistics and where can we find statistics. There's really two main sources of statistics. One is the Federal Department of Education Civil Rights Data Collection. If you go to that ProPublica article that went out yesterday, you can actually search some of that data, or you can go to the US Department of Education website. A lot of that data tends to run a few years behind because of the way reporting works, but they will break down discipline data for school districts. Also now, in part because of the law that was passed in Illinois in 2015, there is a requirement that school districts report to the Illinois State Board of Education who they're suspending, expulsions, and alternative school transfers. And that's where some of those numbers that we cited today come from. If you want to find that data, you can go to isbe.net, so isbe.net /discipline, and they have those numbers. And they also, because of the state law that was passed, ISB is required to target the schools that are at the top 20% of those numbers, which leads some advocates to point out that there is an incentive to underreport your numbers. And I would say in general, with all of these numbers, we do feel like there's a good reason to believe that everything is underreported, and not either because it wasn't actually documented, it was an informal push out, or because it was just not reported to the state. We had a question about how often do expulsion situations get to state court. So I don't know I can't really say the numbers because, right, expulsion hearings happen at an administrative level and then the school board votes on them. The only reason it would go into state court is if a parent and student want to essentially appeal that decision by filing a petition for cert. So there's a decent amount of case law around this, but I couldn't give you a statistic on how many of those cases actually end up going into state court. I would guess not many, because again, I don't think there's a lot of knowledge by parents about what rights might have been violated in the process. We had a question about expungements, then I'm gonna kick over to Rich. And Rich, the question was, are people ever informed of their right to expunge and the process to expunge? When would this happen?
Okay, so one of the great changes that was brought about by a law that passed in 2018 called the Youth Opportunity and Fairness Act and went into effect January 1st of 2018 is that in juvenile court, so in the juvenile court cases themselves, they're informed of that when the ultimate decision happens in the case. So when the case is dismissed, and it's even better, they dismiss the case and they expunge the court record and the arrest record in the case when it's dismissed. So if it's nollied, if it's SOL'd, if it's a not guilty, the judge lets the juvenile respondent know about that and then expunges the record. If there's a guilty and the youth is put on probation, there's a waiting period until 2 years after the probation ends for the expungement to happen, and there's informing the person about that, and then the case is set when probation ends. It's set for a 2-year date, so that if certain crimes haven't happened between the time the case is dismissed and that 2-year date, that the record will be automatically expunged. So that's one place, and probably the most often place that people are informed. We do a lot of outreach work on the issue to try to get the information out there. How does it destigmatize people? This is really an unusual thing, and one of the things our staff have noticed is the number of kids who say, I thought once I had that arrest, it was all over. I couldn't apply for a job because somehow it would turn up on things. So it's probably the most harmful of all the myths, just because people know that records are out there and they lose hope. And one of the most heartwarming and happiest things is when we do follow-up surveys on some of our clients. And they say, I've got a job. I didn't think I'd ever have a job. Or they say, you know, I used to get picked up all the time by the police. Since the expungements have happened, I haven't, and I now have a job, and I now have some hope in my life. And so even though maybe people with, you know, law school educations or otherwise say, oh, well, you know, it's not a conviction, it's not an adjudication, it really doesn't matter, or you can clear this up, or whatever else we think. On the street, there is a feeling among many that they will not be able to get jobs if this happens, and expunging a juvenile record helps to destigmatize that, and it helps people to get jobs.
Thanks, Rich. We got a couple questions about alternative schools, so I'll try and just give more information about alternative schools. So an alternative school would be a school that students are essentially in because they've either been pushed out or sometimes chosen to leave the school that they were in. In CPS, they are sometimes called the options schools, which is different from the Options for Knowledge school choice program, a little confusing there. But essentially, they are filled with students who are forcibly transferred there through an alternative school transfer, or who were expelled but are basically allowed to go to an alternative school. They are traditionally operated by the school district. Sometimes they're operated privately and the school district pays to send students there. But really the problem with alternative schools is, one, it's not your neighborhood school. You're going to be away from your peers. You're going to be further from home. You may not get transportation there, so you have to find a way to get there. The course offerings are going to be less. There's not going to be as many course offerings in terms of electives or in terms of, you know, higher level courses or college prep. As much college or career counseling. It's essentially a lesser education for many students. So that's what it looks like in reality. So I want to differentiate this from a special education school. So there are also schools that sometimes are referred to as therapeutic day schools. That would be a school that is supposed to serve students who have IEPs, who have special education services, and who might have a behavioral or emotional disability. And those schools really have, and you would hope, additional behavior supports, additional social work supports, perhaps therapists or psychologists on staff. They have people trained in behavior analysis, things of that nature that it can address the student's disability. That would not be what an alternative school looks like. An alternative school is essentially a school that's going to look even more locked down, even more restrictive, and with less options. It's very disincentivizing to a student to be in that environment. Someone asked, how does COVID affect the student hearings? We've heard different things, but like we've seen a lot of things in school right now, it's just happening remotely. People are having hearings in the special education context and in the school discipline context remotely. Right now, we have not seen any cases come in from students who are being expelled for something that occurred during remote learning, although that certainly is happening. We just haven't had one of those cases. All the cases we have right now are for things that happened right before schools closed down. Someone asked, is there any type of civil action you can make against the school after they illegally push out a student? So if they illegally push out a student, like our example of Brittany, we went to the school and said, this is illegal and here's all the ways this is illegal, and they let her back in. If they had not, then yes, we could have gone into court and pointed out all the ways that the statute requires that they have a hearing. It requires that they exhaust interventions. It requires that they show that there was a safety threat or a substantial disruption and that they hadn't done any of those things. So you can go into state court essentially filing a petition for cert or a 1983 claim, basically alleging that whatever happened in that case or should have happened didn't happen for that student. So that would be your cause of action that you'd go in under. It's not subject, school actions are not subject to the administrative review law, so that's your form of a petition for cert. Someone asked, what recourse can a student and or a parent take when CPD administers disproportionate discipline to the student regardless of whether injury is involved? So I want to back up for a second. I think the fact that we even have to ask this question is the problem. One, CPD should never be administering discipline. That's not their job. That's not what they're trained to do. Even if they've gone to SRO training, that's not what they're there for. They don't even know what the school student code of conduct says. They don't know what rights students have when they have disabilities. So they shouldn't be disciplining students at all. Theoretically, they should only be there for safety reasons. But I think as we've heard from the students, and as we've seen just in the news, it doesn't always end up that way. And that's the danger of having police in schools, is that they are put into the position of a disciplinarian when that is not what they're trained or really best spent for. So when, if a Chicago police officer were to, or a police officer from any town were to physically manage a student, your rights against them or your ability to bring a claim against them would be the same as if it was on the street. But it's really outside of the school context. That the Illinois School Code doesn't address that, because the Illinois School Code is talking about school staff, and SROs are not school staff, they are police officers. We had a question of what types of conduct result in expulsion, and another one related saying, could you give a breakdown of the various reasons that schools provide for expulsions? All sorts of conduct could result in an expulsion, and it's not always a safety threat. It's not always something like a gun or drugs or something like that. It could be the student was in a fight, like in the example we gave. It could be, I had a student that was referred for expulsion because he pulled the fire alarm. He was kind of a freshman trying to be cool, and somebody dared him to pull the fire alarm, and he did. And so they wanted to expel him for a year and a half and put him in an alternative school. It could be that a student brought pot to school, although less common now, but we've had students that had, I had a student who was self-medicating with Xanax, and they were gonna expel him. And it could be a wide range of things, but it's not always the things that you think are, that you might think that are the most scary. It could be something much more minor. Let's look down at the bottom. Rich, there's another question down here saying, many youth indicate that they're not able to get a license or employment based on state reports. I'm assuming that it has something to do with DNA. Juvenile court clerk indicating everything has been expunged. I don't know if you know the answer to that.
That's not explicitly covered in the expungement statute. What it talks about is the law enforcement records and the juvenile court records, meaning the court file and all the documents in the file being destroyed, and the record of the case being destroyed. The Act does not explicitly talk about DNA.
Okay.
And there was another question also on suspended sentence. And so if by suspended sentence, they mean it's the end of, when does that become eligible? So I'm assuming that a suspended sentence, the youth was adjudicated guilty and was given a suspended sentence of, okay, we're not giving you probation, the case is over today. So if the case is over today, then that would become eligible 2 years from that last date of the case. And it would be a discretionary, because up to the judge, because whether to grant it. So you're eligible, but it's discretionary. And that would be 2 years after that very last day of the case.
Okay, thanks, Rich. Someone asked, how do schools who are having to issue a finding that a student has been a substantial disruption before being expelled, how is substantial disruption defined, and what agency creates that definition? It isn't defined. The school gets to decide it, but what we're seeing is that they don't even really make that determination. At the very basic level, they should at least be introducing evidence at the hearing that shows that how they've decided that the student is going to be a substantial disruption, and they don't even do that. And this goes to another question that we had from someone is, are administrators aware? I think administrators are aware that the law changed in 2016 and requires these extra steps, but I think unfortunately it's turned into just kind of another checkbox that gets checked off. Did we exhaust interventions? Check. And we see very little actual compliance with the spirit of that law. And I think that also has to do with the fact that school staff and administrators sometimes feel like they don't have the resources to implement behavioral interventions, to have alternatives to discipline, and they're not really left with a lot of ideas or thoughts about that. And so this is a matter of also working with schools and helping educators to figure out what are some of the ways that are alternatives to discipline that do and are proven to work, like restorative justice, where a lot of schools pay a lot of lip service to restorative justice, but they aren't really implementing it in an appropriate way. So I do think it's a matter of teachers and staff are aware of these changes, but don't necessarily have the resources to implement them. And so it's a two-part process, really, enforcing our clients' rights, but also schools have a lot of work to do in supporting the people in the classroom. Rich, this is a short question. If the case was in a suburb, not Chicago, where does the juvenile get a rap sheet?
The juvenile, there's a number of different answers. So number one, if they contact our office and they contact the Juvenile Expungement Help Desk, which is 312-433-5565, and we can post that number later on. I'm fairly sure that that's the number. It'll ring at juvenile. So if they're in Cook County, what we can do by getting releases and going via email or texting and get releases signed, we can then get the release and we can get the record, the rap sheet from juvenile probation. We and a couple of other legal aid organizations have established that relationship with the juvenile probation. Cabrini Green is another agency that has that, and they've co-staffed the help desk with us over the years. And so then we can get the rap sheet from them. So that's answer number one. Sometimes arrests that happen in some suburbs don't necessarily show up on the probation. When the building is open and has access, we are able to, if they come to the building when it's open for broader access, and they come to the help desk, we're able to refer them to probation, and probation then is able to do a fingerprint check and get the Illinois State Police background, which will show some arrests. Finally, they can go to the local police department where the arrest occurred and do a FOIA to get a copy of their juvenile record, or some departments have special procedures relating to juvenile records because they're confidential and sealed. And so you can go to your local police department for that.
I believe Veronica is still on with us, but I think our students had to leave and go back to class. But there was a question about, let me find it, about what do we think would happen if tomorrow, if we were living in normal times, I'm assuming you mean pre-COVID times, what do we think would happen tomorrow if police were taken out of public schools? Would it be a good thing? Veronica, do you want to talk about what you think about that question?
Yeah, I can answer it quickly. I think it'll yes, it'll be a great thing. And it'll force Chicago public schools, right, in the city, and even like ourselves to kind of reimagine and rethink what is safety and what does it mean, right? To kind of ask students like, what makes you safe? Because when you ask students like, what makes you safe, a lot of times they talk about what's happening in their community, right? So we have to make that clear connection, right, of how what's happening in the community plays a role in what's happening in the schools, right? So making sure that there's a relationship, right, so that we can work together. So when we talk about like reimagining schools and like how we can replace like the school police officers, right, with counselors, restorative justice mediators, nurses, right, or art programs. Some of the demands that students made through the campaign was to reallocate that money to go towards cash assistance right now for students who who don't have housing, right, to assist families who are facing incarceration, especially with COVID, right? Like we know that Cook County is what was it called? It was referred to as like the center of COVID where you can get it, right? And so we know that these are things that are affecting our communities. And so it will allow us to kind of make those demands and make them more realistic. Yeah, I think I'll leave it at there, leave it at that. And if you're interested in learning more as to like what students are talking about in terms of how they're working and how they want to talk about safety, I strongly encourage to check out our website and our Student Strike Back page. We did a webinar series too of a week of action where we talked about the history of policing, how we see it in our schools, and alternatives to policing, right? Like our solutions that students are creating as we imagine a schools without police, right? Yeah, thank you.
Thank you, Veronica. I think the other thing, that I think about when we think about what would happen if we took police out of schools tomorrow is, I think the suggestion is not just to take police out, but to replace police with something more supportive. I think one thing that if you were following the news this summer about the different local school councils were voting on whether to retain school resource officers in their individual campuses. And one of the things that was brought up is some of the local school councils were reluctant to do that because if they removed the police officers from the school, the CPS wasn't going to let them use that money to pay for a social worker or a counselor or some other kind of resource. So some of the schools kind of felt like it was giving up a person when they needed as many people as they could. I think a lot of people don't realize that, and this is not just Chicago public schools, but a lot of public schools in Cook County, they don't have a full-time social worker. In elementary schools and CPS, the social workers there maybe once or twice a week, and they are mostly working with the special education students. They do have counselors, but counselors are limited. Probably aware of this, but there's not a lot of social work and counseling resources in our schools, and I think a lot of the students who are working to get police out of schools would like to replace with some sort of services like that. Someone asked about the far side suburbs being reached with these services. We represent people throughout Cook County, so we absolutely go to everywhere in Cook County, including the suburbs. And we would like them to be made more aware, and we're part of our project that Melissa talked about that's coming up that we receive funding for is we're really going to be reaching out and doing more Know Your Rights presentations to parents, students, community groups, because parents aren't always aware that they have rights in this area or that it would even be appropriate to call a lawyer. So that's one thing we're really trying to get the word out about. And I will say that there was another question about what are students and advocates seeing as far as school discipline and CPS right now. I think in CPS, right, school just started last week. So everything's a little chaotic in terms of what are we going to be seeing with remote learning. There's obviously new issues, right? You hear about Zoom bombing or Google bombing. So we anticipate seeing some issues there. But so far, school's just starting. So at this point, we're just trying to get everyone logged in online. But I do want to emphasize that this is not a CPS issue. This is a universal issue. And if you look at some of those numbers in the ProPublica database, CPS is not the worst. So while there's lots of room for improvement with every school district, I don't want to imply that this is a Chicago, especially bad in Chicago, because honestly, some of the school districts that we see are the least kind of working towards improvement are in the suburbs. Veronica, I don't know if you want to answer this. There was a question about, do you have any parent involvement in this topic? I don't know if Brighton Park has parents that they work with in addition to the youth directly. Is this something that you guys organize parents around as well?
Yeah, yeah. So a lot of our parents, because of our parent mentor programs and stuff, like we have a lot of parents who are very connected with our schools and are very connected with our student leaders. And we do work together for a lot of like the LSCs and stuff. We made sure to connect with the parents who were a part of the local school councils as a way to build connections with them, but also like, hey, like we're students and we want to talk about this issue that you're about to vote on, right? So we brought parents in through that way, and also making that clear connection of how when we talk about student safety, like it comes like deportation, right? Like the GAIN database and the roles like with finding out how schools are trying to hyper surveil students, right, through this new access of technology. So still engaging in those conversations, and that's something that they're that we're trying to find ways to continue to build a campaign on, like the student and parent relationships, and making sure that when we create a plan, right, of like, what would it look like to have schools without police? What does it look like to reimagine safety, that they're a part of those conversations too.
Yeah, thank you, Veronica. You know, and I got a question earlier that I answered over typing about, you know, are students engaged in our services when we come? And I would, number one, we represent the student, not the parent. So they're our client. So absolutely, I've never had a client come in and say, I don't really want to go back to school. Students who are struggling for a reason, and they don't typically want to just drop out. That is very rare in our work. And if they did want to drop out, we wouldn't represent them. But I honestly have never had that happen. So while it's usually mom or dad who calls us, ultimately it's the student that I'm advocating for. And they always want to be back at school. We got a question about where are the school expulsion hearings held and when. So it could be a variety of places. It could be in front of the full school board, or it could be in front of the hearing officer. Mostly it's in front of a hearing officer. And usually it happens on a weekday, sometimes during school hours. Like in the case of our client Dustin, it happened in the middle of the school day when he was supposed to be taking a final. But sometimes it happens at night. It's not unusual for us to have a hearing that starts at 5 o'clock because school staff comes after they're done teaching. So it usually is held somewhere on school property or at district headquarters or something of that nature. We also got a question about what resources, if any, are available for students to make up the gaps in learning students may miss due to discipline. So the hope is that if you're suspended, you should never be suspended for more than 10 days in a row. And another thing that changed when that law passed in 2015 and went into effect in 2016 is that students have a right to make up work for equivalent credit. So that is a very important thing as well, that if a student misses a quiz during a suspension or misses homework, they have a right to make up that work and get full credit for it. So that's really important for their grades. In terms of missed content, that's really difficult because if they ask a teacher and the teacher doesn't have time to work with them during lunch or something, then they just missed content and they get behind. And that's really kind of the crux of how you lead to these negative outcomes, especially for those students who are being repeatedly pushed out and suspended. They're missing a lot of instruction, and it's a big problem. I don't know the answer to the question about CLE for paralegals, but I'll have someone else maybe answer that. And I think we might be done. If anybody else has any other questions, let us know.
Ask me if somebody can post a question of what's the number for the help desk. I can then post it as an answer. It's 312-433-5655. So if people in the suburbs or in the city want to know how to get the records, even during the time of COVID remotely, they can call that number and leave a message.
Right. So that's the Juvenile Expungement Help Desk. If
yes,
and Brian is looking for representation in a school discipline matter, they can just call our general intake line, which is on our website. It's also 312-341-1070.
And it looks like the number has now gone out to all the juvenile one has now gone out to all the panelists and everybody.
Okay. I just want to thank Veronica for being here. Thank you so much. Obviously, our students had to leave, but Veronica, please pass on our thanks to them as well. And thank you all for attending today.
Thanks.
We appreciate you joining us today. If you haven't already, we invite you to sign up on our website at legalaidchicago.org to attend our remaining presentations in this series. Our next presentation will be next Wednesday on September 23rd at noon and will be on health inequities. Thank you again, and please enjoy the rest of your afternoon.